Hi class, this is Mr. Tan again, and we are in business law, and we are now focusing on P6, question 6, which is the last question in business law before the merits and distinction criteria. So P6 says recommend legal solutions based upon different countries' legal systems and or different legal frameworks. So recommend, so provide a recommendation on legal solutions based on different countries, different countries, legal systems and or different legal frameworks. So the case was with Jackson Limited and DM Motors. So the first thing that you need to do is outline the case in terms of what is happening. And the case is between Jackson Limited, it's an Italian company who produce steel, and DM Motors, which is a British company, and they produce the manufacturing of cars. Now DM Motors have entered into a contract with Jackson Limited, and they have entered into an arbitration agreement within the terms and conditions in writing in the contract, which states that if there are any disputes between the companies, then before anything goes to court, then it must go to arbitration first before it goes to court. And subsequently, Jackson Limited was supposed to supply steel on a certain day, and they didn't supply the steel on that day. And then they gave DM Motors another delivery day for the steel, and I believe it was 20th of August, and again on that day they failed to deliver. Subsequently, DM Motors lost a contract for £50,000. They decide to, for breach of contract, decides to go to court and to sue Jackson Limited for this breach of non-performance. So, what do you think? Do you think they need to go to court, or do you think they need to go to arbitration? Good. They have to go to arbitration. But after you've explained that, we need to explain what arbitration is, don't we? So, arbitration is an agreement between the parties to submit to arbitration to all certain and to certain disputes which have arisen or may arise between them in respect of defined legal relationship. Whether contractual or not, an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. An arbitration agreement must be in writing. It cannot be verbal. And an arbitration agreement is in writing if its content is recorded in any form, whether or not the arbitration agreement or contract has been conducted orally, by conduct, or by any other means. So it has to be recorded. So it must be met by some electronic communication, and its information contained therein is accessible so as to be usable for subsequent reference. And also, in reference to the contract or any document containing an arbitration clause constitutes an arbitration agreement in writing, provided that the reference is such that to make the clause part of the contract. So in the case of DM Motors and Jackson Limited, it was deemed and it was put in writing, so there is an arbitration clause there. So you quite rightly pointed out that DM Motors does not have an option but to go to arbitration first. So the first thing you need to do is explain the case. The second thing you need to do is explain and define what arbitration is, go through all the different points of arbitration and the fact that what it is, it must be in writing, it must be communicated, and so on and so forth. And then the next thing you need to do is to talk about a legal case in common law in the UK and legal requirements in other countries to meet the learning outcomes. So the case in question is going to be Arab African Energy Court Limited versus Netherlands BV, which found that in this case under English law, this case went to court, and because there was an arbitration clause in it, the judge held that it cannot go to court first, it must go to arbitration first. Okay, so that's the case that you must quote for the English legal system, and you must quote that case. Now, the legislation in another country is in New York, and the arbitration agreements are valid under the Convention of the Recognition and Enforcement of Foreign Arbitration Awards, New York, 1958. Okay, so again, you have one legal system in New York and a common law in the UK in terms of case precedent, common law. You must quote both of those to show that you've actually communicated legislation and case law, common law, in two different countries, in the USA and in the UK. Yeah, is everyone clear on that? So we can see that there is a valid arbitration clause, and we can see that DM Motors is going to really waste their time going to court and waste their costs and everything else, so they have to go to arbitration. Now, the next part of the question is this. So that's the first part, advice. So they have to go through arbitration. The next part of the question says, what's the difference between institutional and ad hoc arbitration? So what's the difference between institutional and ad hoc arbitration? So we can see that institutional arbitration is an arbitration conducted by an independent company. It's a company that conducts these arbitrations all the time. And this is what they do. They have professional people who work in these companies. Now, they expect payment up front, and their fees are going to be more expensive than ad hoc arbitration. In addition to that, institutional arbitration have set stages. Stage 1, 2, 3, 4, 5, and 6. They have a number of stages. And they will go through all these different stages. They won't change the stages to suit the companies, but they will go through. So they're quite firm, they're quite rigid and inflexible as regards to going through a process which they've developed over a period of time. And if you buy into an institution arbitration, then you will have to go through their different stages, and it will be more time consuming and more costly than an ad hoc arbitration. But the good thing about this is you have a large number of people in institutional arbitration who are professionals in their fields and who know what they're doing, because they do this as their job. And the other added benefit on institutional arbitration is the fact that it's more well recognized if these cases did have to go to court. So if it had to go to court, a judge would recognize an institutional arbitration more so than an ad hoc arbitration. In direct comparison, we can see that an ad hoc arbitration is more flexible and less bureaucratic, in that you determine the stages you want to go through. You determine the people you want to bring in to be the arbitrators, and you don't have to pay them up front. And you don't have to pay them as much as an institutional arbitration, because the institutional arbitration has all their costs. The arbitrator you call in will be agreed by both parties, and then that arbitrator will then listen to the concerns of both parties, and then once they've listened to it, they would give their advice, and then once they've given their advice, they would invoice the company, and then the companies would pay. And it won't be as much as an institutional arbitration. It will be quicker, it will be more flexible, and it will suit the needs of the companies concerned. However, an ad hoc arbitration in the eyes of the law may not be seen to have as much legal substance as an institutional arbitration. So we can see that the difference between institutional and ad hoc arbitration. Do not do it in a table format. You need to write paragraphs. Okay? So you can't do it in a table format. You must write it in paragraphs. And again, all the information are on the online class. Okay? So does anyone have any questions on P6? No? Okay. Thank you very much.